Lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I don't know you. I don't know how dangerous of a person you are. I don't know if I give you a bond, are you going to go back? I don't know. I know that you're going to tell me it's little gumdrops and rainbows, but how you are on paper tells me who you are, because everybody tells me one thing, but when they get on paper, they're a completely different person. So I got to get to know you before we set you a bond. So Amy, tell us about Miss Howard.
Yes, Judge. She's wanted from Navajo County, Nebraska, for burglary, felony 2A, theft of unlawful taking 5,000 plus, and conspiracy to commit a class 2A. State is opposed to a bond based, one, on the charges that she's wanted for, two, on the fact that she has previously been a fugitive in your court.
Oh, really?
Yes, from South Carolina for robbery.
What happened with that case? Do you know?
I believe they picked her up in that case. Yes, they picked her up in that case. Her most recent conviction was also back in 2024 for an speeding with a motor vehicle out of Defendant County. Day has also indicated to me that she is on federal probation right now.
That's out of Arkansas, Judge. That's what she's on bond for. She is on the has the leg monitor on for that.
What's she on federal probation for?
What are you on probation out for?
I think like a drug conspiracy charge.
Where?
A conspiracy?
Out of where?
Arkansas.
That's the case at Arkansas, Judge.
Possession with intent to distribute, it looks like. Her release date is 2021.
So is that different from what she has in Nebraska, the federal probation case, or are you talking about, is that the same one?
Nebraska should be different. What she's wanted for right now is the burglary. So the basis of the probation, the federal probation, would be the possession with intent to distribute.
Got it.
That's out of Arkansas. When she was in Arkansas, Nebraska put a hold on her, but they didn't come get her.
So let's get this right. Here in Harris County, in 22, you have a burglary of a building, a failure to identify oneself as a fugitive from justice, meaning you're trying to evade law enforcement. You have a prior fugitive case from 21. You have another failure to ID from 2024. You're on federal probation in some other state. You have another open burglary in Nebraska, and you had an evading in a motor vehicle in Montgomery County. And you want me to set you a bond?
Monday, the 10th. All right.
Should I? Really?
Ms. Howard, how long have you been in Houston? How long have you lived in Houston?
All my life.
Okay. You currently were on a probation and you have a leg monitor pursuant to that, correct?
Right.
Okay. And you had a leg monitor on you when they pulled you over, is that correct?
Right.
Okay. Did you attempt to flee from at that time?
No.
Okay. And that's what you're aware of that case up in Nebraska?
Not until my lawyer had told me to turn myself in, but they said it was going to give me a court date for that.
I don't want you to talk about the cases now.
Okay.
How old are you, ma'am? How old are you?
24.
You're 24 and you have all those priors. You scare me, Miss Howard. You truly do. Because if I put my name on a bond, I don't want something bad to happen. And as history dictates, and as the paper says, it's, sometimes we have to protect people from themselves because they're their own worst enemy. You know, you scare me. I can't give you a bond. It's hopscotch with states with the criminality. It can't just happen. And you have a prior one from here as well. I just can't do it, man. It just, at some point, it comes time, the bill comes due. That's now.
You already executed a waiver, Judge.
This moment in the courtroom wasn't loud. There was no shouting, no emotional outbursts, no dramatic collapse at the podium. Yet, it was one of the heaviest decisions a judge can make, because it wasn't about punishment yet. It was about trust, or more accurately, the complete absence of it. When the judge opened by saying, "Good morning, Miss Howard," the tone was calm, almost gentle. But that calm didn't mean comfort. It meant caution. From the very first sentence, the judge made one thing clear. Bond is not automatic. Bond is not a favor. Bond is earned, and it starts with credibility. The judge admitted something many defendants forget. I don't know you. And that matters because when a judge doesn't know you, the only version of you that exists in that courtroom is the one written on paper, and paper doesn't lie out of emotion. It doesn't explain itself. It simply records patterns. And in this case, the pattern was impossible to ignore. What unfolded next wasn't speculation. It was a timeline. A criminal history that didn't stay in one city, one county, or even one state. Nebraska, South Carolina, Arkansas, Texas, burglary, robbery, evading, failure to identify. Federal probation, a leg monitor already in place. I added weight, not because of its severity alone, but because of its consistency. This wasn't a single bad decision. This was movement state to state. While the justice system tried to catch up, when the prosecutor explained that the state opposed bond, it wasn't framed as punishment. It was framed as risk. Risk to the public. Risk of flight. Risk that if released, history would simply repeat itself again, somewhere else. And then came the moment that shifted everything. The judge didn't say, "You're dangerous." He said, "You scare me." Not out of anger, out of responsibility. That distinction matters. Judges don't get scared because they're emotional. They get scared because once they sign a bond, their name is attached to whatever happens next. If someone doesn't show up, if someone reoffends, if someone gets hurt, that decision doesn't disappear. It follows. The judge explains something most people don't want to hear. Sometimes the court has to protect people from themselves, because patterns don't correct themselves without intervention. And at 24 years old, with this many prior interactions with law enforcement across multiple states, the concern wasn't just what had already happened. It was what might happen next. When Miss Howard spoke, her answers were short, polite, careful. She didn't argue. She didn't deny everything. She didn't explode. But she also couldn't undo what was already documented. A leg monitor doesn't symbolize compliance. It symbolizes supervision because trust has already been broken. The judge acknowledged her age and in doing so made the decision even heavier. Because 24 is young, but it's also old enough for consequences to arrive in full. That's when the judge said the line that defines this hearing. The bill comes due. And that wasn't cruelty. It was accountability. The justice system is often criticized for being either too harsh or too lenient. But moments like this show the balance judges are forced to strike every single day. This wasn't about making an example. It was about refusing to ignore a warning. Sin that had already been flashing for years. Bond isn't a right when someone has demonstrated a repeated inability or unwillingness to follow conditions, appear in court, or stay within the law, especially when those violations stretch across jurisdictions. In the end, the denial of bond wasn't dramatic. It was final, and that's what made it powerful. No raised voice, no insult, just a firm line drawn by someone who understood the weight of the decision. This courtroom didn't erupt. It fell quiet because everyone understood what had just happened. A judge looked at a record, looked at a person, and decided that releasing her wasn't just risky, it was irresponsible. And whether you agree or disagree, that's the reality of how justice works. When patterns speak louder than promises, sometimes the most intense courtroom moments aren't about anger or emotion. They're about a judge saying calmly and clearly, "I can't put my name on this." And once those words are spoken, there's nothing left to argue.